1 of the rules of this court permits the court to, permits parties to, upon the close of pleadings, elect or agree for a trial on record. The procedure in trial on record is that the claimant, that the parties rely only on the pleadings and exhibits front-loaded for the determination of the suit, and thereby dispense with the need for oral testimony and or cross-examination of witnesses. In view of the procedure in Order 38, Rule 33(1), this suit is to be determined on the basis of the pleadings of the parties and the documents front-loaded with the pleadings. This is to determine this suit. Thus, to determine this suit, the starting point is to examine the facts pleaded by the parties. I have gone on to review the facts pleaded by the claimant, as well as the facts pleaded by the first defendant, and indeed facts pleaded by the second defendant. They are all fully reviewed. And then I have mentioned the final written addresses. And then my decision, I'll proceed to my decision. In paragraph 23, of the amended statement of defense filed by the first defendant averred that it shall raise at the hearing of this suit the issues whether or not the claimants have any locus to institute this action, and whether or not this court has jurisdiction to entertain the suit. In issue 1 of the first defendant's final address, it was submitted that the claimant's suit is statute barred by the effect of Section 12 of the NNPC Act, and that the claimants have no local standing to institute or maintain this suit. Elaborate arguments were made on the 2 points in paragraphs 11 to 41 of the first defendant's final address. The claimant's responses to the 2 points of objection are contained in paragraphs 2.04 to 2.23 of their final written address. I've considered the arguments made by the parties for and against the 2 points of objection. The first defendant relied on Section 12 of the NNPC Act in its contention that this suit is statute barred. The NNPC Act has been repealed in Section 310, Sub 1A of the Petroleum Industry Act 2021. As at the date this court was considering the objection of the first defendant, the act under which the objection was brought was no longer a valid legislation. I cannot therefore use a repealed legislation to determine whether or not this suit is statute barred. On the issue that the claimants lack local standing to institute the suit, Order 11 Rules 1 and 4 of the rules of this court grants a right of action on a next of kin or beneficiary or a person appointed as the administrator of the estate of a deceased employee who died intestate to claim for the outstanding salary, gratuity, pensions, benefits, or any other entitlement of a deceased employee from the employer. The rule requires the claimant to produce proof of the next of kinship or relationship or letter of administration to be entitled to bring and maintain the action. The claimants have shown in paragraphs 1, 2, and 25 of the amended statement of facts that they are the wife and daughter, respectively, of Mr. Wilfred Chukwuemeka Eze, who died intestate on 19th April 2019. The claimants also disclosed that they are the administrators of the estate of the late Mr. Wilfred Chukwuemeka Eze. I have seen the letter of administration granted on 31st May 2020 by the probate registry of the High Court of Enugu State to the claimants as administrators of the estate of Mr. Wilfred Chukwuemeka Eze. The claimants also showed that Mr. Wilfred was appointed into the service of the first defendant in 1993 and he was retired in 1995. According to the claimants, Mr. Wilfred was not paid his pension and gratuity until he died in 2019. Their claims in this case are principally for the court to determine whether Mr. Chukwuemeka was entitled to be paid pension and gratuity by the first defendant, and if the court finds in the affirmative, to make orders compelling the first defendant to pay his entitlement to the claimants, being the beneficiaries and administrators of his estate. Where salaries, allowances, pension, gratuity, and other benefits is owed to an employee who has died, his next of kin, beneficiary of his estate, or an appointed administrator for his estate is vested with the local standing to sue the employer to recover their outstanding payments. In other words, a claim for outstanding salary, gratuity, pension benefit, and any other entitlement of a deceased employee survives the deceased employee and can be recovered in an action by the next of kin, beneficiary, or the appointed administrator. I find that the claimants have shown sufficient local standard to institute this suit. The second defendant filed a statement of defense where it sought a total of 8 claims in paragraph 8 thereof. The claims were not headed or indicated to be a counterclaim. The claims set out in paragraph 8 of the statement of defense of the second defendant are in violation of the provisions of Order 32, Rule 5 of the Rules of this Court, and they are accordingly struck out. The parties in this suit having consented to the procedure of trial on record, this suit will accordingly be determined using only the facts pleaded by the parties and the documents front-loaded by them, as well as their final written address. I have observed from the facts pleaded by the claimants and the first defendant that the issue involved in this suit is simply whether or not the late Mr. Wilfred Chukwuemeka Eze is entitled to be paid pension and gratuity by the first defendant after his retirement from the service of the first defendant. I think this issue can conveniently be resolved from the pleaded facts and the documents front-loaded by the parties. The case of the claimants, I have, it looks like a repetition, which I have already outlined earlier, so I'm just going to skip this part. It's a relieving of the case of the claimant and that of the first defendant. Now, yes, the first defendant is saying that the late Mr. Wilfred Chukwuemeka Eze did not transfer his services to the first defendant. The case of the claimants is all about the failure of the first defendant to pay pension and gratuity, while to pay the pension and gratuity of Mr. Wilfred Chukwuemeka Eze since he was retired. The first thing the claimants are required to establish in this suit to entitle them to an order of this suit to compel the first defendant to pay pension and gratuity of the deceased what has entitled the deceased to be paid pension and gratuity by the first defendant upon retirement from his service. The claimants, however, failed to plead any fact showing that the pension and gratuity which they claim on behalf of Mr. Wilfred was due to him by virtue of the terms of his appointment or the condition of service which regulated his appointment, or the public service rules, or any regulation or law. The claimants did not claim for the payment of the pension and gratuity of Mr. Wilfred on the basis of any condition of service. From their pleading, what they solely relied upon for making the claims is the allegation of the merger of the service of Mr. Chukwuemeka Eze. In paragraph 15 of the amended statement of facts, the claimant pleaded that the Presidency Office of Establishments and Management Services wrote a letter dated 19th May 2097, where it clarified the fact that Mr. Wilfred, please, I'd like you to unmute your mic, to mute your mic, because I'm hearing a phone ringing. If you mute your mic, I probably won't hear it. Where it clarified the fact that Mr. Chukwuemeka Eze's services had been merged and his pensionable services recognized from 1st February 1962 till 12th May 2003, when he would have attained 60 years of age. In the final written address of the claimants, particularly at paragraphs 1.16, 1.17, 1.27, 2.36, 2.58, 2.59, 2.61, and 2.62, it was submitted that the late Mr. Eze was in service from 1st February 1962 when he joined the Federal Civil Service up to the date he was compulsorily retired from the service of the first defendant. It was argued that the service of Mr. Eze in the Federal Civil Service was merged with his service in the first defendant, and this merger of service made him pensionable in the services of the first defendant. It was argued that late Mr. Eze, having rendered 25 years of service, part of which was in the service of the first defendant, he is entitled to gratuity and pension from the first defendant. Counsel for the claimants further argued that where a civil servant transfers or merges his services, he becomes pensionable at the last place of his employment, in the public service by reason of the merger of his services. It was the conclusion of learned counsel relying on the case of New Nigeria Development Company Limited versus Daniel Ugbabe 2022 that the first defendant is under obligation to pay Mr. Wilfred Chukwuemeka's pension, being his last employer. The implication of the submissions of learned counsel for the claimants is that the service of Mr. Eze in the civil service was merged with his appointment into the services of the first defendant, so that the period of service with the first defendant is a continuation of his service in the civil service. The argument that there was merger of the service with his appointment into the first defendant is founded on the letter dated 19th May 1997 from the Presidency, Office of Establishments and Management Services, to the Accountant General of the Federation. The content of the letter reads as follows. Mr. W.C. Eze, Merging of Services. I'm directed to refer to your letter reference number E9932 dated 19th February 1986 on the above issue, and to state that Mr. W.C. Eze's request has been granted. Accordingly, his pensionable service is recognized from 1st February 1962 till 12th May 2003, when he attained 60 years of age, but excluding periods of unemployment from 26 June 1976 to 31st July 1976 and 1st August 1977 to 13th August 1977, which will be non-pensionable. Inform him, please. The first defendant denied knowledge of this letter. It averred that it never received any letter from the Presidency, Office of Establishments and Management Services on the issue of merger of service of the late Mr. Wilfred Eze. The letter of 19th May 1997 was addressed to the Accountant General of the Federation, Federal Ministry of Finance, where late Mr. Eze worked before he was appointed into the service of the first defendant. And as such, the first defendant could not have given effect to the letter, which it never received. I have seen facts pleaded by the parties showing that late Mr. Eze was in the civil service before his appointment into the first defendant. See paragraph 4 of the amended statement of facts and paragraph 18 of first defendant's amended statement of defense. However, particulars of his services and places where he served were not stated except the Federal Ministry of Finance, where he was serving before his appointment to the first defendant. Now, the question is whether the appointment of Mr. Eze into the services of the first defendant was a continuation of his employment in the civil service. The claimants relied on the letter dated 19th May 1997 from the Presidency, Office of Establishment and Management Services. I've examined the letter. It was addressed to the Accountant General of the Federation and not to the first defendant. The date of the letter is also a date almost 2 years after Mr. Wilfred had been retired from the service of the first defendant. By addressing the letter to the Accountant General, Federal Ministry of Finance, where Mr. Eze served before he was appointed by the head of service, the writer appears to believe Mr. Wilfred Eze was still in the service of the Federal Ministry of Finance as he calculated his retirement date up to May 2003. I also observed in the letter that the application or request for merger of service was made since February 1986. That was about 7 years before his appointment into the service of the first defendant. Thus, the letter of 19th May 1997 could not have been the evidence of merger of the service of Mr. Eze with his appointment into the first defendant. Importantly, there is no reference in the letter to the merger of the service of Mr. Eze with his appointment into the services of the first defendant. In other words, the letter dated 19th May 1997 is not the evidence of merger of the service of Mr. Eze with his appointment into the service of the first defendant. Other than this letter, the claimants did not plead any fact to show that the service of Mr. Eze was merged with his appointment into the service of the first defendant. I've gone further to examine the other documents front-loaded by the claimants to see if I can find evidence of merger or transfer of service to the first defendant. The claimants pleaded the facts of the appointment of Mr. Eze with the first defendant in paragraphs 4 to 7. Paragraph 4 to 7 of the amended statement of facts The claimants averred that by a letter dated 11th October 1993, the first defendant conveyed the approval of the Secretary of Petroleum and Mineral Resources for the appointment of Mr. Wilfred Chukwuemeka Eze as the acting group executive director of finance and accounts in the first defendants. Also, by a press release dated 2nd November 1993, the then head of state, Chief Ernest Shoneko, approved the appointment of Mr. Wilfred Eze as the group executive director, finance and accounts of the first defendant. The first defendant thereafter issued a letter of appointment dated 3rd November 1993 to Mr. Eze. The letter of appointment as the acting group executive director dated 11th October 1993 reads as follows. Acting appointment as group executive director, finance and accounts. It is my pleasure to convey to you the approval of Honorable Secretary of Petroleum and Mineral Resources of your acting appointment as group executive director, finance and accounts in NNPC. The salary attached to this position is 162,400 naira per annum on the corporation's GSS 16. The fringe benefits and other terms of the acting appointment are as contained in NNPC conditions of service. The appointment takes effect from 8 October 1993. On assumption of duty, please report to the office of the Group Managing Director, 7 Kofo Abayomi Street, Victoria Island, Lagos. Please accept our congratulations. We look forward to your contribution in the service of the corporation. The press release dated 2nd November 1993 also reads as follows. The head of state, Commander-in-Chief of the Armed Forces, Chief Ernest Shoneko, has approved the appointment of Mr. C.O. Oyipo as the Group Managing Director of the NNPC. The head of state also approved the appointment of 6 other executive directors. They are the Group Executive Director Downstream, Alhaji D.A. Bayero, Group Executive Director Upstream, Mr. Chief G.T. Grant, Group Executive Director Corporate Services, Alhaji I.M. Dapchi, Group Executive Director NAPIMS, Chief M.A. Olongfemi, Group Executive Director Commercial, Chief E.D. Ekan, and Group Executive Director Finance and Accounts, Mr. W.C. Eze. The letter of appointment of Mr. Eze as the Group Executive Director, dated 3rd November, reads as follows, 1993. Letter of appointment. I am pleased to convey to you the approval of the Honorable Secretary, Petroleum and Mineral Resources, for your appointment as Group Executive Director, Finance and Accounts on the corporation's GSS 16 salary of 162,400 per annum. The appointment takes effect from 2nd November 1993. We are expected to conclude handing over or taking over and assume duties as your new post on or before 8 November 1993. I wish you a successful tenure of office and look forward to your further contributions in the NNPC. These documents did not indicate that the appointment of Mr. Wilfred was a transfer of service or merger or a promotion in the civil service. To further show that the appointment of Mr. Wilfred as GED Finance and Accounts was not a transfer, secondment, or deployment, the Federal Ministry of Finance wrote the letter dated 23rd May 1995 to the first defendant, where it stated as follows in paragraphs 2 and 3. I wish to draw your attention to the fact that Mr. W.C. Eze was not on secondment to the NNPC, and for this reason, he cannot be deseconded. Mr. Eze was actually appointed Group Executive Director, Finance and Accounts by the former head of state, Chief Ernest Shoneko, in November 1993. His appointment to this position can only be annulled by the head of state. I'm therefore advising you to withdraw the letter and recall Mr. Eze to resume his work immediately. The content of the above documents reveal that the appointment of Mr. Eze as Group Executive Director in the first defendant was a new appointment made by the head of state, independent of his employment in the civil service. His appointment was also at the pleasure of the head of state and not subject to the control of the third defendant, Federal Civil Service Commission. This fact was clarified in the letter dated 14th June 1995 from the Presidency, Office of the Secretary to the Government of the Federation, to the first defendant. The second paragraph of the letter reads, I am directed to emphasize the fact that Mr. Eze was appointed the GED Finance and Accounts along with 5 others in November 1993 by former head of state as indicated in the NNPC press release of 2nd November 1993. It is therefore logical that the appointment can only be terminated on the approval of the head of state. The fact that the appointment of Mr. Eze was detached from his service in the civil service was further demonstrated by the manner he was retired from service of the first defendant. His letter of retirement dated 7th August from the Ministry of Petroleum and Mineral Resources reads thus: Retirement from service of the corporation. I wish to inform you that the head of state and commander-in-chief of the armed forces has approved your retirement from the services of NNPC in line with the stipulations of Decree number 17 of 1984, effective from the 7th August 1995. The retirement of Mr. Eze from his appointment into the service of first defendant was done by the head of state who appointed him and not by the third defendant. Thus, the facts of this case and the documents produced before the court show clearly that the appointment of Mr. W.C. Eze as the Group Director of Finance and Accounts was not a measure of service or transfer of service. Thus, being a fresh appointment made by the head of state, the claimant served the first defendant from November 1993 when he was appointed to August 1995 when he was retired from the service of the first defendant. It is to be noted that Mr. Wilfred Chukwuemeka Eze did not challenge his retirement by the head of state up till the time he died. It is clear from the foregoing that the measure of service relied upon by the claimants to found their claim does not avail them. This is also in addition to the fact that they did not base their claim on any condition of service applicable to the appointment of Mr. Eze. The first defendant averred that Mr. Chukwuemeka Eze was in the service of the first defendant for 1 year, 9 months, and 5 days only, and his entitlement is only limited to the time he worked with the first defendant in accordance with the first defendant's employment rules and regulations at the time. The first defendant relied on the provision of Section 16.4.83 of the first defendant's condition of service and averred that late Mr. Eze was not entitled to pension and gratuity from the first defendant because his year of service in the first defendant was below 10 years, which was the minimum years of service that could have entitled him to pension and gratuity. The claimants did not file a reply to the first defendant's statement of defense. Therefore, the claimants did not dispute these averments of the first defendant. It was, however, argued in the claimant's final written address that the condition of service of the first defendant was invalid and not applicable to the employment of Mr. Eze. It was argued that the employment of Mr. Eze in the Federal Civil Service, including his service in the first defendant, was regulated by the Civil Service Rules, which is a bylaw under the Constitution and not by the condition of service of the first defendant. It was further argued that they don't take precedence over the Civil Service Rules. I've carefully examined the facts pleaded by the claimants, but I cannot find anywhere they pleaded that the employment of Mr. Eze in the Federal Civil Service, including his service in the first defendant, was regulated by the Civil Service Rules. The claimants did not plead the condition of service which regulated the employment of Mr. Eze, nor did they plead the condition of service or regulation or law which entitled him to be paid pension and gratuity by the first defendant. The claimants merely relied on measure of service or continuity of service. Also, the claimants did not traverse the averments of the first defendant in paragraphs 8, 16, and 17 of the Statement of Defense, where it pleaded that the entitlement of Mr. Eze to gratuity and pension was regulated by its condition of service. I have also seen the letter written by the first defendant dated 11th October 1993 to Mr. Eze, informing him of his appointment as acting group executive director. The second paragraph of the letter mentioned that the fringe benefits and other terms of the acting appointment are as contained in NNPC condition of service. It was the acting appointment that metamorphosed into a substantive appointment by the head of state in November 1993. The implication is that the condition of service which regulated his appointment in the first defendant was the first defendant's condition of service. I've also had counsel for the claimants argue that parastatals and agencies of the federal government like the first defendant, are bound by the public service rules and cannot have their condition of service outside the public service rules. This submission of counsel, in my view, is not sound in view of the provision of rules 160101 and 160103 of the old repealed public service rules applicable up to the time this suit was instituted in 2020. Rule 160101 defined a parastatal as a government-owned organization established by statute to render specified services to the public, while Rule 160103 gives parastatals the liberty to make their internal condition of service made in line with the general principles contained in the public service rules to regulate their employment. But in the absence of an internal condition of service, provisions of the PSR shall apply. The first defendant, no doubt, is a creation of statute and a parastatal of the federal government. By these provisions of the PSR, the first defendant is empowered to make a condition of service for his employees and to apply same in regulating his relationship with his employees. Accordingly, the condition of service made by the first defendant pursuant to this provision of the PSR is valid, effective, and applicable to those employed into the service of the first defendant, including to Mr. Wilfred Chukwuemeka Eze, as he was informed in the letter dated 11th October 1993. The first defendant front-loaded its condition of service. I have seen section 16.4, where it established the pension and gratuity scheme, and section 16.4.4, which provides that the scheme is applicable to all employees on permanent appointment, excluding those on contract appointment. For those eligible to be paid gratuity, section 16.4.82 provides as follows. Non-eligibility for gratuity. An employee who has less than 10 years continuous employment with the corporation or whose service has been transferred or seconded to the corporation from any public service of Nigeria and whose period of eligible for gratuity under the scheme. I have also examined section 16.4.88 of the first defendant's condition of service, which provides as follows. Period of service. Duration of service counted under this scheme shall be interpreted as unbroken period of service for the purposes of computation of and payments of benefits. The transfer or secondment from all scheduled service shall be regarded as continuous service. The cumulative years from which all such services shall constitute one unbroken service in conjunction with whatever length of service an employee puts in the service of the corporation. I have made the findings earlier in this judgment that the service of Mr. Eze was not transferred to the first defendant. He was also not on secondment to the first defendant. The Federal Ministry of Finance and the Office of the Secretary of the Government of the Federation confirmed this fact in their letters to the first defendant dated 23rd May 1995 and 14 June 1995. I have also resolved earlier in this judgment that the claimants did not show that there was a merger of the service of Mr. Eze with the first defendant. Therefore, the provisions of section 16.8.8 of the first defendant's condition of service will not apply to deem the years of service of Mr. Eze to constitute one unbroken service in combination with the period of his service with the defendant. By section 16.4.8 of the first defendant's condition of service, an employee on permanent appointment with the first defendant would not be entitled to gratuity on two conditions: where he is less than 10 years in the employment of the first defendant, where as a transferred or seconded employee, his period of service in first defendant is less than 10 years. In the case of Mr. Eze, he was less than 10 years in the employment of the first defendant. He was barely 2 years in the appointment when he was retired by his appointer. He was therefore not eligible to be paid gratuity under the first defendant's condition of service. To conclude this judgment, I ought to make these clarifications. Mr. Eze's service in the civil service was not transferred or seconded or merged to his service with the first defendant. His appointment by the head of state was a fresh appointment, even though from the civil service. It was more like a political appointment. He ought to have resigned or retired from the civil service to take up the appointment, or he could have applied for leave of absence. That way, he could have been entitled to his benefits for the years he had served in the civil service. Again, when he was retired from his appointment into the service of the first defendant, it was that appointment that was terminated. From the letter dated 19th May 1997, Mr. Eze was not due to retire Mr. Eze was not due to retire from the civil service until 2003. He should have been reabsorbed into the civil service. Perhaps he did not make that attempt. Rather, he spent years writing demand letters for his pension and gratuity to the wrong organization. The circumstances of this case are such that I do not find any strong reason to make the orders sought against the first defendant, even though the claimants pleaded facts which tend to stimulate the sympathy of this court towards the sufferings Mr. Wilfred went through before he died. Courts of law do not decide cases on the basis of sympathy, but on satisfactory proof of the claims sought by the parties. Although the claimants were able to establish the declaration sought in Relief 1, the facts pleaded by them do not entitle them to the grant of all other claims sought by them. In the result, the declaration sought in Relief 1 is made accordingly, while Reliefs 2, 3, 4, 5, 6, 7, 8, and 9 and 10 are dismissed. Parties shall bear their respective costs. Judgment is entered accordingly.
As the court pleases. My Lord, we thank my Lord for the judgment. We pray that the Lord
Thank you.
strengthen you the more. Amen.
Thank you very much. So you get a copy of your judgment hopefully later today. At this rate, we are already running for time now. I still have one more to deliver. Then I will get the files back to Mohammed, and then he can give you your copies.
Okay, my Lord.
Thank you.
Thank you. Thank you.
Mohammed, there's one more. He has disappeared again. Is counsel on the other matter present?
Wait now.
Mohammed. Mohammed. It looks like I'm alone on this Zoom meeting now. Is Mohammed present? Is counsel for the other in the other matter present?
No. Network.
Yes, is counsel present? Are the parties in court? No. Baba, I'm not on the. Are they hearing me? Mhm. Interesting. Yeah. Okay. Okay, is counsel in court? Are the parties present? On mute, let me hear from you.
Parties absent, Lord.
Okay.
Yes, Lord.
Appearances. Is counsel in court?
Yes, Lord.
Let me hear him here. His mic is muted now. Yes.
My Lord, please.
Yes.
My name is Okoro Tochukwu Prosper. I humbly
Yes.
appear for the claimant, my Lord.
Thank you.
Thank you, my Lord.
Almost.
So I'm going to deliver the judgment right away, and I'll be reading directly from my system. The claimant instituted this action against the defendant on 14th March 2023. In his amended statement of facts filed on 13th November 2023, he sought the following claims against the defendants. I've reeled out the claims there. There are 12 of them, and they are already embedded in the body of the judgment. I have also summarized the case of the claimant and gone on to to summarize the case of the claimants, the defendants, but none of them filed a statement of defense in the suit. None of them entered appearance in the suit and were not represented despite service of several hearing notices on them. The result is that the defendants refused to participate in the suit and they were accordingly foreclosed from defending the suit. The claimant filed his final written address on the 14th of May 2025, where he formulated a sole issue for the determination of the court. I have evaluated and considered all the submissions and arguments canvassed in the final written address of the claimant. I do not see the need to rehash the content here. However, necessary reference will be made to them in the course of the judgment. Now to my decision. The claimant was a policeman employed into the service of the first defendant on 1st June 2000. He was dismissed from the service of the first defendant in June 2013 via the signal marked Exhibit B. It's okay. The claimant brought the suit to challenge his dismissal, whereby he sought in relief one, a declaration that his dismissal was unlawful. He also sought consequential orders, setting aside the dismissal, reinstating him back to service, promoting him to the rank of his mates, and payment of arrears of his salaries. See reliefs 4, 5, 6, and 7. I have stated earlier that the defendants did not file a statement of defense in this suit. They did not call evidence. It was on this account the learned counsel for the claimant submitted in paragraphs 4.8 to 4.14 of the claimant's final written address that the facts and the evidence presented by the claimant were not challenged by the defendants, and the implication is that admitted by the defendant. Counsel added that the claims used are therefore deemed established. I cannot fault the argument. That principle of law is not applicable in all circumstances where the defendant did not file defense or defend the suit. One of such situations is where the claimant's principal claim is a declaratory claim. Declaratory claims are grantable only upon cogent, satisfactory, and credible proof of claims by the claimant. Such claims cannot be granted on the basis of admission by the defendant or on the weakness of the defendant's case, or even on want of evidence from the defendant. See Yusuf versus Mashi 2017. In Ada versus Ubandawaki 2015, the Supreme Court held that the burden of proof on the plaintiff is establishing declaratory reliefs to the satisfaction of the court is quite heavy, in the sense that such declaratory reliefs are not granted even on admission by the defendant, where the claimant fails to establish his entitlement to the declaration by his own evidence. The weakness of the defendant's case does not assist the plaintiff's case. He swims or sinks with his own case. In this case, the claims in reliefs 1, 2, and 3 are declaratory claims. It therefore means that the fact that the defendants did not file a defense or adduce evidence does not entitle the claimant to automatic success of these claims. The burden of proof is squarely on the plaintiff, and where he fails to prove his case will be thrown out, notwithstanding the fact that the defendants did not defend the suit. See Elegushi versus Oseni 2005, Ogunyade versus Oshunke 2007. Accordingly, the claims of the claimant are to be considered and determined solely on the basis of the evidence adduced by him and the success or failure of his claims, depending on the strength of the evidence adduced in proof of his claims. It is settled law that where a claimant seeks that his dismissal from his employment be declared unlawful or wrongful, the determination of the court of the claim is principally based on the terms and conditions of the employment contract. The claimant, in order to succeed in his claim, is expected to plead and prove the terms and conditions of his employment, the circumstances under which he can be dismissed from the employment under the conditions of service, the procedure stipulated in the condition of service for dismissal, and the manner in which the dismissal reached the said terms and conditions of his employment. See Petroleum Training Institute versus Matthew 2012, WAEC versus Oshonebo 2007. It is therefore clear that this court can only determine the wrongfulness or the unlawfulness of the claimant's dismissal on the basis of the terms and conditions of his employment. Accordingly, the first duty placed on the claimant, who is asking this court to declare his dismissal to be unlawful, is to plead and prove the terms of his employment and show how his dismissal breached the terms and conditions of his employment. I have carefully examined the averments of the claimants as well as the evidence adduced by him. In his pleadings, the claimant did not mention the condition of service which regulated his employment with the first defendant, and he did not plead the procedure for termination of his employment or dismissal from the service of the first defendant. The claimant did not also plead any fact suggesting that his dismissal was done in breach of any term of his employment. It is the same situation with the evidence adduced by the claimant. In all, the claimant failed to show that his dismissal was done in breach of the terms and conditions of his employment. From the evidence given by the claimant, it is observed that his claim of unlawful dismissal is based only on his allegation of being denied fair hearing by the orderly room trial. As can be seen in reliefs 2 and 3 sought by the claimant, he sought the court to declare that the defendants violated his right to fair hearing. In his evidence, the claimant said after the first orderly room trial of 1st April 2012, he applied to appeal the orderly room trial, but his application was denied, resulting to his being denied the right to be heard. In the second orderly room trial on 26 April 2013, he was not allowed to cross-examine or ask any questions from the suspect, Nonso Ikegwonu, who testified against him. For this reason, the claimant said his right to fair hearing was violated by the defendants in the orderly room trial. By the evidence, the claimant's claim of unlawful dismissal is clearly founded on his allegations of denial of fair hearing, rather than on breach of the terms and conditions was violated by the defendants in the orderly room trial. He did not link the allegation to any provision of the condition of service. That is to say, the claimant's allegation of denial of fair hearing have not been shown by him to be based on any breach of the terms and condition of service regulating the employment. The claimant cannot rely on breach of fair hearing alone to challenge the dismissal without showing that the breach of his right to fair hearing arose from the breach of the terms and conditions of his employment. In Aji versus Chad Basin Development Authority 2016, the Supreme Court held thus, quote, what can be stated to be solid rock position of the law with regards to an action by an aggrieved employee on the termination or dismissal from service is that to find this case, there is no running away from pleading and proving his contract of service to substantiate his claim. In the case at hand, throughout the particulars of claim, there is no plea of the condition of service governing his employment with the respondent. And in evidence, nothing is put forward from those conditions from which those conditions can be ferreted out, and no document evidencing the condition of service. It therefore needs to be said that waving the flag of a breach of fair hearing entrenched in the Constitution as per Section 33 of the Constitution of the Federal Republic of Nigeria, prevailing at the time of the action's commencement, which section is in pari materia with the current Section 36 of the Constitution of the Federal Republic of Nigeria, does not provide the saving grace. This is because in the absence of pleading and establishing the contract of service, the court is left without the working tools with which it can consider the case advanced by the employee as to whether or not there was breach. In other words, the breach cannot exist in vacuum, and such a situation produces the absence of a condition precedent which cannot be waived, being fundamental, unquote. The claimant cannot found his case solely on the ground allegation of denial of fair hearing. He must, as of necessity, found his case on the condition of service, and it is only in the basis of the condition of service that the wrongful nature of his dismissal can be determined. The issue of fair hearing or lack of it is tied to proof of the terms and conditions of the employment. Therefore, in the absence of proof of that, the dismissal violated the terms. Therefore, in the absence of proof that the dismissal violated the terms of his employment, proof of the fact that the dismissal violated the terms of his employment, the reliance on breach of fair hearing alone cannot sustain the case of the claimant. See Zide versus Rivers State Civil Service Commission 2007. Consequently, the claimant is not entitled to the declarations he sought in reliefs 2 and 3. The failure of the claimant to mention the condition of service which regulated his employment with the first defendant also affects reliefs 4, 5, 6, and 7, where he sought orders setting aside the dismissal, reinstating him back to service, promoting him to the rank of his mates, and payment of arrears of his salaries. Reliefs of this nature are available to employments which are protected by statute, but the statute must be stated. See Ikale versus Fan, Isebore versus NEPA, where an employment or a contract of service is shown to be governed by the provisions of statute, or where the conditions of service are incorporated into regulations which derive their force from a statute. The employment of the employee who is a party to such contract of service is said to be protected by statute. The claimant has not asked the court to declare that his employment is protected by statute. See Imolame versus Wayek, Oluseye versus Loma, Where such an employment contract is found to be terminated in breach of the terms of the applicable statutory provisions, the employee is entitled to have the termination set aside and reinstated. When the claimant failed to plead the condition of service which regulated his employment with the first defendant, he equally failed to show that his employment is protected by statute. Although the first defendant is a statutory body, not all employment by statutory bodies has statutory flavor. Thus, until the claimant pleads and proves the condition of service which regulated his employment with the first defendant, this court cannot assume that his employment with the first defendant was statutorily regulated. In the absence of proof by the claimant that the terms and conditions of his employment are statutory, he failed to present any basis for this court to consider or grant reliefs 4, 5, 6, and 7 sought by him. The claimant attempted to claim that the allegation of negligence in the escape of Nonso Ikegwonu, an armed robbery suspect from the cell for which he was dismissed, was unfounded. See what he claims in Relief 1. In his evidence, the claimant said the suspect does not know him and he did not play any part in the suspect's escape from the police cell. He also claimed that CSP James Nwafo may have masterminded the events in order to fulfill his threat to have the claimant dismissed from service. Now, in his evidence, the claimant confirmed that he was on duty with 3 other officers on the day the suspect escaped from cell. He said when the suspect was transferred to his SARS unit cell, he participated in questioning the suspect before the suspect was put into the cell that night, only for them to discover in the morning that the suspect had escaped from the cell. The claimant did not explain how the suspect was able to escape while he was on duty, as to show that the escape did not happen as a result of the negligence of all the officers on duty or with active connivance of the officers on duty, including himself. How did a suspect on handcuffs and locked up in a cell escape from the cell in the presence of 4 police officers on duty? It is easy to infer negligence on the part of the officers or even believe that the officers on duty participated in facilitating the escape of the suspect. I find the claimant's attempt to extricate himself from the escape of the suspect as a feeble attempt. I have thoroughly considered the case of the claimant, but I find no merit in it. The claims sought by the claimants have not been proved. The suit fails completely and it is accordingly dismissed. No order as to cost. Judgment is entered accordingly.
Ask copies.
So I'll get you get your copy of the judgment as soon as Mohammed can reach me. So hold him onto it. And then that will be all for the day. Thank you very much. So I'll leave the meeting room now.
Thank you.